do have a question on intermediary partnerships.
Yes.
You can consider partnerships as separate legal entities, and they can sue with a partnership name. Now, if you get sued, though, there's still no difference between getting sued individually and having more partnerships.
You're going. We'll see that.
Okay.
It depends whether it's a tort issue or a contract issue. But we'll talk about that.
Okay.
Just let me not get too far ahead. So the duty of loyalty, as we talked, okay. The partners have a duty not to act adversely to the interests of the partnership. This duty, remember I said certain things you can agree to and have an arrangement with each other regarding. You can't do that with respect to loyalty. You can't put in a partnership agreement that we don't have to be loyal to one another. That's a duty imposed by law which cannot be waived. In the event of a conflict between a partner's interest and his or her personal interest, they must choose the interest of the partnership, or they have breached the duty of loyalty. What are some examples? Self-dealing. You want to know what self-dealing is?
So you use the assets of the partnership and sell them and keep the profits for yourself.
Self-dealing could be that. Dealing with a partnership without permission. We are going to, as a partnership, we need to buy widgets from XYZ Corporation. And I, as a partner, don't disclose to the other partners that I'm a silent partner in XYZ Corporation. That's self-dealing. That's breaching the duty of loyalty to the other partners. It's also breaching the duty to inform the other partners of all things concerning the partnership. Right? Usurping a partnership opportunity. What does that mean? The partnership wants to buy those same widgets from a company. I don't have any personal interest in the company, but I'm able to negotiate a really super low price for those widgets. And I go to the company and say, I know I'm here, I'm here for the benefit of the company, but I'd like to buy these widgets for myself, and I'll sell them on the side. That's an opportunity that belongs to the partnership, right? If I take the opportunity to myself, that's called usurping the partnership's opportunity. The only way I would be able to do that is if I first present the opportunity to the partnership, and after due consideration, the partnership decides for whatever reason it does not want to take advantage of the opportunity. Then I can take advantage if I want to. That make sense? Compete with the partnership without permission. We own a car dealership. Me and, what's your name, sir? Bernie? Me and Bernie own a car dealership. We're general partners. I can't go down the street and open up a competing car dealership. Because that would be competing against our partnership. I would breach my duty of loyalty if I did that. Unless Bernie agreed to allow it. Would Bernie do that? No. Like, say we have a Mercedes dealership, right? I tell you, hey, we're doing good. I want to open up a little used car dealership. He said, no, I can do it. If he said, or she said, he didn't mind. He says, I have a problem with that. If I do it anyway, I breach my duty of loyalty. It's not doesn't matter. Because his argument will be that it is. Because the same people that might buy a used car, low end, might also buy a used Mercedes if it's cheaper. We sell those to dealership, right? We sell, get a trade in. So he would have an argument that it is a competing business, right? I can't make secret profits. the partnership business. I go to negotiate for widgets, and I say, I'll give you the deal if you give me a kickback. Kickback is a secret profit that belongs to who?
The partnership.
The partnership. Cannot disclose confidential partnership information, trade secrets, client lists, confidential phone numbers, the names and addresses of our clients. That's confidential information that I have to keep for the partnership. Misuse of partnership property. Using the photocopy machine in our car dealership to make photocopies for my real estate business on the side. Misuse of partnership property. Or any other breaches of our fiduciary or duty of trust to one another. The duty of care, again, the same level of care skills as a reasonable person in the same position would use in the same circumstances. Breaching that is negligence. And a partner is liable to the partnership for any damages caused by his or her negligence, and that will be decided by what? Right of accounting. Duty to inform, again, we have a duty to each other to inform each other of all information that's relevant to the affairs of the partnership, because that knowledge is imputed to all of us as partners. Obedience, again, simply means adhering to the decisions that we make as a partnership by way of majority vote. And here's the right of accounting. Partners cannot sue the partnership. They can bring an action for an accounting, which is a formal judicial proceeding where the court is authorized to review the partnership and the actions of the partners and award each partner his or her share of the partnership assets. Now, you got to watch this really carefully. Tort liability and contract liability is different when it comes to our partnership. What's the tort? Civil wrong committed against a person or property other than a breach of contract, right? So a partnership is liable for the tortious act of a partner, an employee, or an agent committed while the person is acting within the ordinary course of partnership business or with the authority of his or her partner. Both negligence and intentional torts are both covered. Now, when we say tort liability, as opposed to contract, when we say tort liability, we're talking about being both joint and severally liable. What do I mean by that? That means all of us collectively as general partners are individually liable, and we're also severally liable. What that means is partners, the plaintiff can sue one or more of the partners separately, or name all of us. And if they are successful in their lawsuit, the third party can recover the entire amount of the judgment from any or all of the defendant named partners. Release of one partner does not release the others. In other words, a person who has done something wrong in the partnership finds all of us to liability. But the plaintiff has a choice on whether to sue all of us or sue the one person that caused the damage. They have a choice. Okay? So let's say Lauren and Jennifer and Angela and I are all general partners. Angela goes and hits a pedestrian while on partnership business. Okay? The plaintiff can decide to sue all four of us and the partnership, but we're jointly liable. So all of us are equally liable. The plaintiff can decide to sue of us, and if she wins the lawsuit, all of us are equally liable. Okay? Or she can decide to just sue Angela, since Angela is the one that caused the accident. If she just sues Angela and wins, okay, who's going to be liable? Everyone who's named. Oh, just you. What? But here's the key. Once the liability has been established, okay, and the partnership is liable, all of us are liable. Let's look at this case. It'll be crystal clear. On page 630, there's a case of two doctors. I said a partnership is liable for the tortious act of a partner, and a partner is jointly and severally liable for tortious acts charged to the partnership. Got that? Jose Pena and Joseph Antonucci were both medical doctors who were partners in medical practice. Both doctors treated Elaine Zuckerman during her pregnancy. Her son Daniel was born with severe physical problems. Elaine, as Daniel's mother and natural guardian, brought a medical malpractice suit against both doctors. The jury found that Pena was guilty of medical malpractice, but Antonucci was not. So she goes to this medical practice that's owned as a joint partnership by two doctors. During her pregnancy, both doctors treated her. Child was born with a birth defect. She sues both doctors, and it was found out in court that only one doctor actually did something wrong. The doctor did not. The amount of the verdict totaled $4 million. The trial court entered judgment against Pena, the doctor who committed the malpractice, but not against Antonucci. The plaintiffs made a post-trial motion for judgment against both defendants. Question: is Antonucci, the doctor who did not commit the malpractice, jointly and severally liable for the medical malpractice of his partner, Pena? Yes or no? Yes? You want to say no? Here's what the court said. A partnership is liable for the tortious act of a partner, and a partner is jointly and severally liable for tortious acts chargeable to the partnership. That's the key. When a tort is committed by the partnership, the wrong is imputed to all of the partners, jointly and severally. And an action may be brought against all or any of them in their individual capacities or against the partnership as an entity. So if a person is wronged by a general partnership, they have the option of suing the general partnership, suing any one or more of the general partners, or suing them all. Once any one of those entities is found guilty, the liability is imputed to all. Got that? Hang on. Do we have that so far? No? Okay. Therefore, even though the jury found that defendant Antonucci was not guilty of any malpractice in his treatment of the patient, but that Pena, his partner, was guilty of malpractice in his treatment of the patient, they were then both jointly and severally liable for the malpractice committed by defendant Pena by operation of law. The court held that both partners were jointly and severally liable for the judgment. So, Antonucci, let's say, was the deep pocket partner. So, if Pena, who was guilty of the malpractice, could not pay, what's the plaintiff going to do? Get the money from Antonucci, right? Kind of a downside to the general partnership. Would you say?
Yeah.
Your partner screws up, you pay the price too. Now let's look at that and contrast that with contract liability. Remember, I could decide who to sue in a joint and several, right? I can jointly sue everybody, or I can just decide to just sue one. When it comes to contract liability, the partners are only jointly liable for contracts of the debt in partnership. I shouldn't say only. I should say the partners are jointly liable. What does that mean? Any third party, in our case with Angela, Lauren, Jennifer, and I, Angela goes out and commits a tort or a contract breach, I should say. The third party must name all of us in the lawsuit. And if she does not name all of us in the lawsuit, then all of us are released from the lawsuit. So in the case of the plaintiff suing just Angela, let's say the plaintiff was a friend of our business. And the plaintiff was friends with me, my personal friend. Friends with Jennifer, and friends with Lauren. And friends with Angela, but Angela committed the tort. So the plaintiff wants to sue Angela. This is under tort, right? Wants to sue Angela, but not us. Because we're friends and she doesn't want to put us through the trial because Angela really is the person who hurt her, right? She has that option. And we're off the hook and we're still friends with this person who's playing, right? In a contract situation, that friend would not have that option. If the friend wants redress, or the third party wants redress for that wrong committed against them by our partnership, they must name all of us as defendants. That's what jointly means. We're all jointly liable. Got it? And if they don't name all of us, then all of us are released.
All like
Yes. If all of us are not named, none of us are named because we're jointly liable.
so if they just mess up their complaints, then we all get off.
Well, they wouldn't do that. It would be malpractice by the attorney that did that, right?
Right.
So, right.
For the important notices, you added, I think, other parties.
Right. But you want to make sure that everybody who's a partner is named. Now, once they are successful in the judgment, they collect against any and all the partners. Right? And then a partner who was not the cause of the accident, like the three of us, we can now get indemnification from Angela for what part we had to pay. Because let's say all four of us are named, and Jennifer's the deep pocket, so the plaintiff collects from Jennifer, because the other three of us don't have any money, but we're guilty also, and we're liable also. Okay? For that, say, $4 million judgment, she's got $20 million in the bank. She's going to pay the $24 million. Because all of the other three of us are destined, we don't have it, but she does. So she has to pay. But she can seek indemnification, all right, from the rest of us for whatever we do have. But it's not the plaintiff's problem, is what I'm trying to say. The plaintiff gets a judgment against the general partnership for contract liability. All the named partners are liable for the whole judgment. So whoever has the money is the one who's going to pay the judgment. Yeah.
And towards war contract liability, does it matter if one of the partners is being sued on something unrelated to the business, or is it the exact same?
Well, if it's unrelated to the business, then the business is not going to be named. Let's say you're on vacation somewhere in Hawaii. Now, business,
Right.
you're on vacation in Arizona. That's not related to the business. You're going to be liable on your own.
But if I lose, can I not go after all my assets and judge?
All of your assets, yes, but not the partnership.
Yeah. What's the difference? If the only money I make is from the partnership?
If all you make from the money you make from the partnership is what you have and what they go after, they'll go after your interest in the partnership.
Okay.
But not, they can't go after the whole partnership, they go after your interest in the partnership.
Okay.
So your paycheck might be garnished, or your profits might be garnished, or whatever assets you have that you would get in a distribution, that can be.
Okay, but they can't go after the business.
Not unless you were doing something in the normal course of partnership, then the partnership would be named, right? But if you get someone on vacation, that's not partnership business. The partnership is not liable for that. Your own insurance company is going to be involved in that, right? But if it's more than your insurance takes, then it'll come after your assets. One of your assets is your ownership interest in the partnership. So they'll come after that, right? In the way of garnishing your profits, whatever you get from the partnership.
So that's different. So if I was a sole proprietorship, then it
It wouldn't
wouldn't.
matter. It wouldn't matter. No matter what judgment they get, and whether or not you were doing sole proprietorship business, it's the same thing. Not separate. Yeah.
Out of a partnership already voted out, like what if someone wanted out of a partnership, like the reason why.
I'll get into that. Yep, that's towards the end. That's winding down the dissolution. I'll get into that.
If all partners separately liable, they need to sue any or all of them. Let's say you're damaged for $1 million, you sue each of them and get a judgment against each of them for $1 million, and they never cover anything else.
No. That's why with the contract issue, you got to name them all. That
Right.
resolves that.
I had the same question with force liability.
With tort liability, what you're going to do is you're going to make a strategic decision. And in most cases, you're just going to name everybody. Attorneys always are going to try to name everybody. It's just that there's a distinction between tort liability, which is joint and several. You have the option of whether or not to name everybody. Okay, but only the ones that you name are the ones who you can get the judgment against.
Right, but if they, like, for some reason, they, like, one of the defendants decides that they have less liability than one seven, they're faced with the other one. And so, is it just one judgment for just the total amount of damages?
But you don't decide that, though. You're the defendant. You can't decide, I'm going to sever my case. That's going to be the plaintiff deciding not to name you or to dismiss you. You can't, as a defendant, dismiss yourself from the case, right?
Well, let me just separate the things so there's like they like your let's say Jennifer has
So then who are you going to sue?
third party sues me, Jennifer, and Angela. And
For tort or contract?
for torts.
Okay.
I don't think that I have any liability for that. And I'm like, I want they're suing us as individuals. And I was like, well, I don't want my liability to be kind of their liability.
You don't have a choice of that. Because you're a defendant, and by law, they can name you. And you're named, and you have to defend yourself with that action.
Okay. So the third party is going to recover up to the amount of judgment they can like have like a judgment for a million damages. Each of us go.
No, because that's more than the judgment. They can collect $1 million in however many increments they need to get to $1 million.
Right.
Once they get $1 million, that's the judgment.
Okay.
They can't get $1 million from you, $1 million from you. That's $3 million.
I'm wondering if I have a judgment against like a judgment against her for a judgment against.
No, because remember, you're jointly and severally liable, but you're fully liable for the debt. Whatever the debt is, each one of you is on the hook for the full amount.
Right.
However, whoever has the money is the one who's going to end up paying, but you're all three liable for the entire amount. Any others? Okay, that's just a graph or chart of how it looks. Liability of incoming partners. A new partner admitted to the partnership is liable for the existing debts of the partnership, which are antecedent debts, but only up to their capital contribution. Very important point. Let's say we have a general partnership. We have two general partners. Right? And we bring in another general partner. This general partnership, at the time that this general partner comes into it, owes $1 in cash. This general partner, okay, when they join the general partnership, contributes $100,000 to the partnership to become a partner. With me so far?
Yes.
This debt, because it existed at the time that I became a general partner, this $1 million that was already owed by the general partnership is called an antecedent debt. With me so far? Now, the general partnership goes on through time and makes a loan for $10 million to purchase a building. Okay? Another year passes by, and the business is unsuccessful and goes under. Owing $10 million plus the $1 million that it already owed. So $11 million is owed. This partner and this partner is on the hook for the $1 million, right? Right? And for the $10 million, right?
Right.
$11 million these two partners are on the hook for. This partner is only on the hook for the $100,000 that they lost. So that's gone, right? All the debt, all the money that the business had is gone. In fact, we'll say it this way. The $10 million is owed. The company went out of business. The $1 million is gone, used up to pay debts, and et cetera, okay? So it's gone. The $100,000 is gone. We still owe $10 million, right? These two guys are on the hook. They lost $1 million, right? They lost that. I lost, as a general partner that started after the fact, I lost my $100,000, right? Because the business has zero capital. Okay? I'll make it clear. Zero capital in a business, you owe $10 million. Right? The $1 million here is gone, and my capital contribution is gone. This $10 million, because it came about after I became a general partner here. Am I on the hook for that?
Yes.
Yes. Are these guys on the hook for that?
Yes.
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 We're all on the hook for this, right?
Yes.
Yeah, I want you to see that first. We're all on the hook for everything that came after, right? Now, let's reverse it a little bit. Let's say that there was this $1 million, not capital contribution, but this $1 million was for a lease that we had before this person became partner. In that case, this $100,000 is gone, right? This $1 million is still out there, right? So say this is a lease that we have, and we still owe on, but it came about before. It's an antecedent debt before I became a partner. But now we have no money. I lost $100,000. Am I responsible for the building?
For the lease?
Am I responsible for the lease? Who says yes? Who says no? I saw 3 and 3. Nobody else has an opinion? No? Yes. I'm only responsible for the money that I put in, my $100,000 capital contribution is gone. I have no further liability because that debt was in place before I became a partner. However, the debts that came about after I became a partner, I'm 100% liable just like everybody else. That makes sense? Should I say that a different way?
Yeah.
A little bit convoluted.
I have a
Okay,
question.
I got you. Hang on, let me clarify this first. The general partnership and the general partners. Okay? We all put in money. Or these guys put in, let's say, $100,000 together. 50 and 50. $100,000 capital. Okay? Maybe this will make it clear. The third party. Okay? Let's say $5 million lease. Outstanding. This person is not a partner yet. Okay, so there's an outstanding debt of $5 million. Okay? Got it? Year goes by, and they say, James, would you like to be a general partner? I say, yes. James, can you put in $100,000? I say, yes. $100,000 of my money, let's make it different. Let's say $200,000 of my money goes into the partnership. Okay? Already, $5 million was owed by the partnership. Okay? That's an antecedent debt already owed when I came on board. The only obligation I have to that debt is the capital contribution that I put in. I don't owe the full $5 million. Just the money that I put in is all that I'm on the hook for of this $5 million. So $4.8 million is not my problem. Right? Now, these two are on the hook for the whole $5 million. Got it? With me? Okay. So I'm only on the hook for what I put into the business. Now, year goes by, we do another contract, this time for $10 million. All three of us are on the hook for the $10 million, right? Right? Only these two are on the hook for the remainder of whatever is owed on the $5 million, right? So let's say the company goes out of business. We burn through the $200,000 capital that I put in because actually they accepted me as a partner because they needed money, right? They were falling apart and they needed somebody to invest. So I was stupid enough to invest, and because of that, we were able to get another $10 million loan or profit, right? But because the business was run poorly, we burned through the $200,000 that I gave. Theirs is already gone. That's how they needed me, and now we go broke. They're on the hook for the whole $5 million. They're on the hook for the $10 million. So they're on the hook for $15 million, right? Me, since all of my money has already been burned through, I have nothing on the $5 million, right? My capital contribution is gone, but that's all I'm on the hook for, right? I lost my $200,000 investment. I don't owe anything on this. However, I owe $10 million on this, along with the others. And what's going to happen? These two parties are going to both sue the partnership, and they're going to sue the general partners. And if any of us has any assets like a house, or stocks and bonds, or other businesses, they're going to attach those to collect their $10 million. All right? These people. This person is not going to bother to sue me. Right? They're going to sue. That's where the joint and several comes in. They may name me, but I'll be dismissed. I'll be able to get dismissed for the reason that there's no standing. And if they continue, all right, after the dismissal, I might have a little lawsuit. Because it's an antecedent debt, and my capital is gone, I have no further legal obligation to this, right? So to name me in a lawsuit, right, when I have no further obligation, is not right, right? I'm probably going to file a motion to dismiss, right? I get dismissed out of that, but I'm not going to get dismissed from this, right? Got it? Is that clear? That make more sense? Yeah.
Let's say we owe the whole $50 million and so they pursue the partnership with $50 million. Would, as you know, to make sure that you do not own this agency debt, would that be something that you file during the trial, or would that just be something included in the judgment?
Well, you would file that before the judgment, right? Because that's going to be found out in discovery anyway, because they're going to ask for documents that show when you're going to be right? When did you become general partner?
Right.
On July 1st. When was that debt initiated? On June 1st or January 1st, the preceding year, right? That establishes it's an antecedent debt, right?
Okay.
But then the party that's suing you is going to next say, you're going to do a motion to dismiss this person, so they're not liable for the debt. Right? Yeah.
Well, if they're also suing the general partnership for $5 million, when they get their judgment, isn't he going to be liable anyway? Because
Not for the antecedent debt. Because they're only liable up to their capital contribution to your general partner, and you have antecedent debt. The ones after that, yes, they will have full liability.
I thought with the general partnership, if one was found responsible, then they all have to pay, and then you have to do the accounts, the right account.
Yeah, but the person here is most likely, if they get found that they have to pay, and usually they'll get dismissed, but if they are found to have to pay for any reason, then they're going to go after a indemnification
Well, what I mean
from the
is,
other party.
are they going to have to pay because they're part of the general partnership and they're suing the general partnership for the $5 million, right?
Yeah.
And the third party is suing the general partnership and he's part of the general partnership, so by default he's going to be
Yes.
responsible.
Yes.
Right, okay.
That clear? Unclear? All right. What she's saying is the general partnership is going to be sued, right? Each one of the general partners, and whether it's this person or this person, they're going to sue the general partnership, get a judgment. Okay? The judgment that this party gets is going to be against the general partnership. Okay? They're going to go after these two people, but let's say this person has the money or has money. Would they be able to get a judgment? Perhaps. But if they did, this person is going to try to get an indemnification from those two. Well, yeah, but still, this person has some kind of recourse because it's an antecedent debt. These two have no recourse because they're fully liable for the whole 15 million. Legally. This person is not legally, well, legally they are, but they have recourse to go after the other two. Does that make sense? Yes?
Yeah.
It's a little complicated. But an incoming partner is going to have an agreement, all right? It's going to specify what happens if they are sued in this kind of a case. Because the Uniform Partnership Agreement or the Uniform Partnership Act specifies that antecedent debts are only up to the capital contribution to come in after that. Okay. Dissolution. Who asked about the dissolution? Okay. Dissolution is a change in the relationship of the partners caused by any partners ceasing to be associated in the carrying on of the business. And what that means is, if any general partner removes himself or herself from the partnership, it dissolves the partnership. And the rationale behind that is because each one of the general partners has unlimited liability. If any of them changes their position, it upsets the balance of the liability as far as percentage-wise. Because usually you're going to have a certain written document that says, I'm responsible for 50% of the dad, 5, and what have you. If a person removes himself from the general partnership, then it dissolves it automatically. And some ways that it can be dissolved are if it's for a term. For instance, if we do a general partnership for 5 years, at the end of the 5 years, the partnership automatically dissolves because it's a term partnership. If we do a partnership that says we will remain partners until XYZ building is constructed. When XYZ building is constructed, partnership dissolves. If we have a partnership at will, well, go back. If we have a partnership for a fixed duration or until an event occurs, and one of us decides to withdraw from the partnership and dissolves the partnership, that will terminate the partnership, but is it rightful or wrongful? Because I don't have what? I don't have the what? The right to do it, right? I always have the power to terminate a general partnership by simply withdrawing, right? But if it's a term partnership, then I have committed myself to that term, right? Or if it's until an event occurs, I have committed myself to that event. If I withdraw and dissolve the partnership before the term or the event, I've committed a wrongful termination and dissolution. And what does that mean? My partners have a right to an accounting, right? For the damages that I caused. Not so in a partnership at will. In a partnership at will, that means any partner can rightfully withdraw and dissolve the partnership at any time. Winding up. That's the process of when you wind up the partnership, you're liquidating the assets, you're selling the building, you're selling the cars, you're selling the vending machine, all of that, to get cash so that you can pay off the creditors, and whatever's left over, distribute it to each other, and you're done. A notice of dissolution is the document that shows that the termination is taking place. And you have to give it to certain parties. A third party who has dealt with the partnership has to be given actual notice that the partnership is being dissolved. Any party who had knowledge of the partnership has to be given constructive notice or actual notice. Any third party does not have to have notice if they have no knowledge of the partnership. And what happens if you don't give notice? What kind of authority? Parent authority, right? Now, the assets in a partnership, remember I said that a partnership, general partnership, can make loans to the partnership? Well, if you dissolve and go out of business, and you're winding up and you're selling all of your assets and getting the cash to start paying off the creditors, the first people in line are the creditors. It would be the lease company, the bank loans, vendor agreements. All those people have to be paid first. And then, if money is left over, the creditor partners are paid. That would be the person who's a partner who made a loan to the company, if there's money available. After those loans are paid off, If any other money is available, you pay back the capital contributions that the partners put in. If there's money available. And after you pay back the capital contributions, if money is available and there are profits left over, then you distribute those profits to the general partner in whatever allocation you guys have the agreement with. Make sense? Now, again, a partner has the power to withdraw, but may not have the right. And if they withdraw wrongfully and terminate the partnership, then they may be liable to the other partners. No, not necessarily. It just means they can't participate. And the reason behind that is because they have a conflict. If I'm bankrupt, that means I have no money, right? If I'm having the wind up of the company, that means I'm going to be handling money, right? Conflict of interest. We don't want a bankrupt partner handling the money of the company because some of the money might be up in it. But any profit that's left over to them, it's their right. The company. What's just going to happen is the bankruptcy court is going to confiscate that money to pay off the bankruptcy debt, right? So, after a partnership is dissolved, the remaining partners have the right to continue, but it will be a new partnership, not the same old partnership. Because once a partner withdraws, it dissolves that partnership, and a new one is created. All the old debts of the old partnership slide right over into the new partnership and it goes forward from that point.
Let's say it's a law doing the general partnership. One of the partners leaves and again a new partner.
That's why the lawsuits first don't do general partnership.
Right. So then they have which kind of winding up with all their clients and reestablish new client contracts.
They don't necessarily have to wind up. They can have a continuation agreement, which within 60 days, if they file this continuation agreement, they can continue on. Okay? But it's still going to be a new partnership. Right. So they don't want that. So law firms are now LLP instead for that reason. Yeah. No. As long as it's still available. You have to do. Did you guys talk about how to name searches and that sort of thing?
No.
Right. Name availability. When you're setting up any kind of business, you have to check with the Secretary of State to make sure that name is not already available or not already used. If it is, you can use it. If it's not, you have to have like several alternate names. So outgoing partners are not discharged from the debt that they owe just because they're no longer a partner. So in this case here, this $10 million that the three of us owe, if I decide I no longer want to be a partner, I'm going to withdraw from the partnership. That doesn't mean I no longer owe this debt. I still owe the debt, regardless of whether or not I'm a partner. Because I was a partner when the debt was incurred. Make sense? Right? So survivorship is upon the death of a partner, the partner dies, the deceased partner's rights in the specific partnership property vest in the remaining partners. It does not pass to their heirs, but the value does. Explain it this way. Let's say there are four of us. Let's say there are three partners here, general partners. And we build 99 restaurants. With me?
Yes.
This partner dies at 99 restaurants. This person's heirs do not receive 33 restaurants. Let's say we have an equal share in profits, equal share in losses, right? This person dies, the heirs do not get 33 restaurants. what they do get is my 33% in the profit from the 99 restaurant. Make sense? I need to say that differently? So what happens is the value that I would have gotten goes to my heirs. But the right of survivorship says that the remaining partners, the property belongs to them. But the value, so when they sit down and do up the profits and losses, and there's a profit of $100,000, my family will get 33. Right?
And we continue to get that?
We continue. If this person dies, then this sole remaining general partner owns 99 restaurants. But when he or she sits up and divvies up the profit, 66,000 will go to the heirs of this party and that party. Okay? Now, when this last partner dies, all 99 restaurants, the value goes to his or her heirs.
Wow.
You want to be the last to die.
Exactly.
All right, that's chapter 4. Any questions so far? We got just enough time to get through limited partnership. Yes? Let's take a second break, but let's come back at, I hate to say this, 11:37.